She's on her way, but she's coming from Oviedo, and the rain might have held her up. So as soon as she gets here, we'll start. Code Board a meeting. Please silence all your cell phones. The city desires to accommodate persons with disabilities. Accordingly, any physically handicapped person pursuant to Chapter 286.26 Florida statutes should at least 48 hours prior to the meeting submit a written request to the chairperson that the physically handicapped person desires to attend the meeting. Any person who decides to appeal any decision of the Code Enforcement Board with respect to any matter considered at this meeting will need a record of the proceedings, and for such purpose may need to ensure that a verbatim record of the proceedings is made, which record includes the testimony and evidence upon which the appeal is to be based. Any person or defendant who requests to review or object to any exhibits presented to the Code Enforcement Board by the City of Titusville prior to submission to the Code Enforcement Board must stand and state their request to review the exhibits prior to review by the board at the time their case or agenda item comes before the board for hearing. Any person found to be in violation of the City of Titusville Code of Ordinances and given a time frame in which to comply shall, upon compliance, be responsible for contacting the Code Enforcement Supervisor for an inspection to verify said compliance. The violation will not be considered to be in compliance until the Code Enforcement Supervisor is notified and verifies compliance. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And we have a quorum. Do you want to do a roll call vote, please, Megan?
Member Herman?
Here.
Member Edwards?
Here.
Member Edens?
Here.
Vice Chairman Beckles? Here. Member Grant?
Here.
Member Monis?
Yes.
Chairman Bell?
Yes. Deborah, would you like to swear in the witnesses, please? Well, does all the city people need to be sworn in? I don't know.
It's my understanding you don't legal arguments and not any factual testimony needed.
In an abundance of caution, I'd prefer that you ask the witnesses that are here to testify to raise their hand and swear to it.
Okay, anyone who intends to testify in this matter, the only matter on the agenda, please raise your right hand, be sworn in. Okay. Swear affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth.
All right. Everybody read the minutes from last month?
I move to approve.
I have a motion by Ashley. Any second? Any second?
Second.
Second by Ariel. Roll call vote. Any discussion? Roll call vote, please.
Member Edwards?
Here.
No. Okay, never mind.
Member Edens?
Yes.
Vice Chairman Beckles?
Yes.
Member Grant?
Yes.
Member Monis?
Yes.
Member Herman?
Yes.
Chairman Bell?
Yes. Minutes approved. Chelsea, would you like to start off, please?
Good afternoon.
Good afternoon.
I hope everyone had a nice 4th of July. The one hearing that's listed on your agenda today is case number 19-28. On June 10th, 2019, the City of Titusville presented the facts of case number 19-28 regarding the property located at 1340 Santa Cruz Avenue and an alleged violation of Code Section 28-9, prohibiting the short-term rental of single-family dwellings in certain zoning categories. In addition to the required exhibits demonstrating notice and due process, I shared with the board 2 critical pieces of evidence that I would like to elaborate upon at this time. The first piece of evidence that I would like to discuss is the Florida Today article from June 10th. Upon review of the Code Board hearing, I realized that I focused on this news article more than the enacting legislation. A copy of the article was provided to each board member, where I highlighted the admission from the respondent, which stated Daniel and his wife rented out 3 rooms and hosted Airbnb guests for 38 nights over the past year. This fact is not in dispute, and I believe it is the best evidence to demonstrate a violation of Code Section 28-9. The second piece of evidence that I would like to discuss is ordinance number 46-2007, a copy of which was attached as Exhibit 2 to the city's motion. Has everyone here received a copy of the city's motion and the Exhibit 2 that is attached to it?
No.
If anybody doesn't have a copy of the ordinance, I have extra copies here with me. Does anyone need a copy of it?
No, I have one now, but I didn't receive it prior to today. So I'm reading it now.
This ordinance was referenced and submitted into evidence on June 10th. However, I do not believe that the board fully appreciated nor applied the ordinance as intended by council and expressed through the introductory recitals. The text of the ordinance specifies the frequency and duration of short-term rental of single-family dwellings. The respondent argued that this board should interpret the ordinance to only apply to the rental of entire dwellings. By following the respondent's interpretation of the code, the board has applied a legislative interpretation on their own initiative. The board must look to the intent of the city council if there is any ambiguity as to what this council intended to prohibit. In this case, the intent was to prohibit commercial activity in specified residential zoning categories. The city wishes to present additional testimony and witnesses to demonstrate the purpose and intent behind Code Section 28-9. In support of this motion, I have here with me today, and available for any future rehearing date, the city attorney, Richard Broom, as well as the former city attorney, Dwight Severs, who are both prepared to testify regarding the purpose and intent of the ordinance 46-2007, as they were the key staff members advising city council at the time the ordinance was enacted. The city of Titusville hereby requests a motion of reconsideration, rescinding the decision of the June 10th, 2019 order and establishing a time certain for the rehearing of the matter. I have met with the attorney for the respondent. He's willing to proceed with this hearing today or at a future date. If there are any questions regarding the city's motion, I'd be happy to answer them at this time.
Will? Never mind, proceed. I'll talk about it later.
That concludes my initial request for a motion for reconsideration as presented to the board. The question on the table is whether the board is willing to entertain a reconsideration of the motion that was previously made in case number 19-28. I'd like to invite Richard Broom to add to the testimony for the city.
May we address that before we go forward, Madam Chairman Bell? Because my understanding is our
You have to speak from the podium, sir.
Can you state your name for the record, please?
Jacob Stewart and my partner Chris Cagle on behalf of the Daniel family, who is the respondent in this action. We were given notice of this hearing and the complaint on the new motion on July 2nd. We agreed to have a hearing today on the motion for reconsideration of a new hearing, not for a new evidentiary hearing, Madam Chairman. So I think to present evidence and all of that, I mean, if we're going to, our position is that there was a hearing, there was a ruling or a finding by this board on June 20th. The city then waited until July 2nd to file a complaint. They have concerns about their right to appeal your finding to the proper circuit court venue, which is 30 days. And they're trying to reopen this for either memorializing or creating a new record, an additional for an appeal, or to rehash issues already talked about. And you don't get, in law, there's a phrase, res judicata, where essentially says something that's already been ruled upon shouldn't be ruled upon again. My understanding, I wasn't here last time, but upon the minutes and the minutes that just were approved, this board already voted and had this issue. The city's now asking you to come back and readdress the entire issue. And that, from a procedural posture, the threshold issue is, and we object to it, is that will you grant them the right to present a new case to you? And so I think that question has to be answered first before they move forward. And if you do allow them to present that over our objection, then we would ask for a new hearing date to be prepared, because my client's due process rights has been violated. Even though we had notice on July 2nd, we've had two business days to get ready. And that's not an appropriate amount of time, in our opinion, to present a case, something that we don't really fully understand what's going on. So I think from our position, for clarification, we agreed to move forward on your vote on whether or not to have a new hearing. And I'd like to, if we're going to do that, I think to put the parameters around it, we have, an argument against that, but I'd like for clarification about what we're actually doing, Madam Chairperson.
I apologize for any confusion. The city's request for a motion for reconsideration is what the city is asking for. In the alternative, a motion for rehearing. The initial step that the city expects this board to take would be a motion for reconsideration to reopen the item that was before you on June 10th. At that time, you may set a date for a hearing if you are willing to vacate the prior order. That is the city's position. If the board is not inclined to reconsider the matter, then that is the board's desire. But I believe that it is appropriate at this time, within a reasonable period after the initial decision, to have an opportunity to reconsider, which would be what the city's request is. If you are not inclined to make that motion to reconsider, the alternative would be that motion for rehearing, which does need to be within that 30-day period. So it is a bit confusing. I have Robert's rules with me, and your board attorney as well will probably be able to advise you if you have questions about procedure.
Basically, what you're asking is for us to make a motion and vote on a reconsideration to reopen the case of June 10th, 2019, correct?
Council, maybe I can get a little clarification. To ask the board to reconsider their decision from last month, would you agree that that would mean that you're asking this board to reconsider the legal conclusion that based on the undisputed facts, that the ordinance was not violated, right? You're asking the board to reconsider that based on your legal arguments.
Yes, ma'am.
Emphasizing what is in your motion
Yes,
for
ma'am.
reconsideration. Okay, so theoretically, how I'm understanding it from a reconsideration standpoint is you're asking the board to essentially decide that based on your legal arguments that there actually was a violation under the
That would be
code.
subsequent to the decision of whether they should reconsider their prior decision.
But if aren't your arguments purely legal arguments? Are you asking the board to rehear the evidence, the factual evidence?
No.
Okay, okay.
I'm not going to argue.
We're going to object. I mean, you haven't
This
made
is
a
not-
decision yet, so for a witness to come
No,
in.
you need to be on the microphone, and
This is not a court of law, so we don't have,
I'm
the
not
rules aren't
offering
as
fact evidence.
stringent
I'm not
as
testifying as
objection
fact
and all
witness.
that
I'm just
stuff.
answering
Yeah.
your question.
This is a city attorney, so I would,
No, I'm talking
I would
I
appreciate
believe the
it.
point is she said, we're asking them to reconsider that legal aspect. Understand the facts are not in dispute. And any testimony I may give is not factual. It's purely as to why they should rehear it based on what they did. I'm not presenting any fact or testimony regarding facts. As to the rehearing itself, this is an argument as to why it should be reheard.
go ahead.
So
Like-
is it the city's position that you would like the board today to reconsider its finding that the property is not in violation by finding the property in violation, based on the legal arguments that you've proposed in the motion?
That's correct.
Okay.
And
That would be your initial request? would-
yes, and my addressing the board is with regard to why it should be reheard.
On the legal arguments?
Correct. I have no facts, right,
Right,
no facts to argue, that's correct. I understand the facts are not in dispute.
Okay, all right.
And again, for those who don't know me, my name is Richard Broom, I'm city attorney. I've been with the city approximately a little over 14 years. I was assistant city attorney in 2007 when this ordinance was drafted, and I did provide some assistance in that regard. Again, let me thank you for your service. As a board, we're just here, and the goal is to ask for the rehearing and let you know what we believe the intent was of that ordinance is drafted. What's also helpful about Ordinance 46, 2007, and I believe you have copies, is that it contains approximately 4 pages of recitals. Very short actual regulation, but about 4 pages of recitals. Why I think that's important is those 4 pages of recitals show the intent of the regulation and why it was important to council, and sets forth the basis for the regulation and guidance as to how it should be interpreted. Throughout those recitals, council refers to the transient and commercial activities associated with short-term rentals, and how those activities or uses associated with the rentals is what they are seeking to prohibit in single-family neighborhoods. The recitals state, and you have that before you, whereas the city council finds that the rental of dwellings or other structures for short-term use by visitors or transients is a commercial activity and is inconsistent with the use of zoning districts devoted to non-transient residential use. Whereas it is the intent of the city council to preserve single-family residential use from encroachment by commercial transient rental activities. Whereas the city council finds that the commercial use of single-family residential property for such purposes as vacation rentals, which by their nature are transient and commercial in nature, creates unmitigatable adverse impacts on surrounding residential uses, including but not limited to increased levels of commercial and residential vehicle, traffic, parking, demand, light and glare, and noise, detrimental to surrounding residential uses and the general welfare of the city. Whereas the city council finds it is proper through the use of zoning to protect the integrity of residential neighborhoods by refusing to allow commercial activities to encroach upon residential areas. Whereas the city council finds that vacation or short-term rental uses are inconsistent with the maintenance and perpetuation of primarily low-density residential character of the city, and that vacation or short-term rental uses are not truly residential in character, but are transient commercial uses. Whereas the city council finds that vacation or short-term rental use is commercial in character. Whereas the city council finds that it is necessary to prohibit rentals for periods of 3 months or less within certain single-family zoning districts in order to preserve the character and integrity of residential neighborhoods. In addition, of course, there was a memo done at that time setting forth the purpose that short-term rentals are conducting business in single-family neighborhoods, which is a prohibited use. And again, as stated in here, it's certain single-family neighborhoods. This doesn't apply citywide. It's only in certain single-family neighborhoods, and that was the intent of councils, to protect single-family neighborhoods from that business and commercial transient activity. These commercial business transient activities, when you do rentals, they exist whether you rent 1 bedroom, 2 bedrooms, as the ordinance says. The intent was to regulate that activity, not to apply it to an entire dwelling. It's any portion of the dwelling that's engaged in that activity. To limit the application of this ordinance to entire dwellings is going to lead to an inequitable and discriminatory result. And we want you to consider that when you're looking at the intent of council. For example, based on the interpretation given, the owner of a 2-bedroom home cannot rent that 2-bedroom home in its entirety, as that would strictly be prohibited under all interpretations. However, your neighbor or the neighbor of the individual who owns a 2-bedroom home can have a 4-bedroom home, 5-bedroom home, rent out 3, 4 bedrooms, reserve 1 bedroom to themselves. And that's okay. Based on the previous interpretation, that has to be an entire dwelling. Now you have twice the impacts, twice the parking, because you have 4 bedrooms being rented, but the individual who owns the 2-bedroom house is prohibited. So it's discriminatory. You have this additional impacts that are being allowed based on that interpretation. So if there's a debate, and I understand there was a debate about the intent, whether it applied to entire dwellings, as stated by the Florida Supreme Court, the cardinal rule of statutory construction is that a statute should be construed so as to ascertain and give effect to the intention of the lawmaker to accomplish, not defeat, their purpose. The purpose was to protect the single-family neighborhoods from the nuisances associated with short-term rentals. And again, that applies whether you're renting 1 bedroom, 2 bedroom, 5 bedrooms. It doesn't depend on whether you rented your entire dwelling. It's the uses. That was the intent. Again, thank you for listening, allowing me to express what I believe the intent of council was, so that the board could carry forward and enforce the intent of council. Thank you.
Does anybody have any questions?
Yeah, how come this wasn't presented on June 10th?
It was.
It was?
She read those to us.
I never received any information,
It was never an exhibit. The
so,
only-
Okay, wait a minute. Go ahead.
On June 10th, 2019, the code board meeting was an hour and 25 minutes long for this one hearing, and I reviewed it in preparation for today's motion for reconsideration.
Right.
And as I pointed out in my introductory statement, I focused too much on the facts at hand and not the background, because I did not expect this argument to be made at that time. And now here I am responding to the argument that was made on June 10th, because there was an argument that the entire dwelling is what the council meant, and that's not what the council meant. And I needed to explain that to you by going through what I did provide as a piece of evidence into the hearing on June 10th. I gave a copy of the ordinance as submitted evidence, and it went down the line, and I didn't give each one of you a copy of it, and I'm sorry for not doing that. I made a mistake. I should have given each one of you a copy of the legislative intent when I made the presentation, but I didn't do that, and now here I am asking you to reconsider the vote that you made.
Are you talking about the summation of 28.9? Is that what you're talking about?
Yes.
Well, that was the key for us saying,
I read those recitals.
you read the recitals, but they were not introduced as an exhibit or evidence or whatever you want to call it. The only thing that was introduced was 28.9, the summation, and it did not spell out
that's right.
anything about partial rooms. It said detached dwelling. And if you can find a copy of the summation that you submitted last month, please, if we're going to have a rehearing, I'd like to have that piece of that exhibit as part of that rehearing, because that was the reason I don't know about Ms. Evans, but that was the reason why I made the decision that I made, because it did not spell out what the law was saying.
The code section is what it says. An owner of a single-family dwelling is prohibited from renting more than 4 times or for less than 3 months. That's what it says. It doesn't say entire or a part of the dwelling. That was the subject of the discussion at the meeting, though. And in response, in my rebuttal, I read the recitals, and I would ask either the board secretary or the board attorney to confirm that I submitted the entire ordinance into evidence, because I did.
You read it for sure, because I was right here, I listened to it.
Okay.
All right? But this was more or less after the fact.
I don't think so.
After we had made our decision.
It was before the decision was made.
It was before. It was before.
I argued in response to the respondents' arguments, and my rebuttal was focused on the recitals, because I focused on the news article in my initial presentation.
Yes.
And my rebuttal said, okay, I'm sorry, you're focusing on the word dwelling. I didn't expect that in preparation for the June 10th meeting.
You yourself said, if our memory serves, that you did not present enough evidence. Am I correct?
I think that there is enough evidence.
I mean, that's what you said.
think that there's the best, I don't recall saying that.
Okay. I'm a gentleman, I'm not going to argue with you.
Me neither, but I will say this, just because it was my first board meeting, didn't mean I didn't understand. And it seems to me, since I broke the tie between you guys, that my answer wasn't good enough. I believe you've already had your one shot at it. I don't think you deserve to get another shot. Period.
Stop.
No, hey, now, I've sat here for a whole month and let this pop me in the forehead, and I'm not a goat for nobody. And whether the people in this audience like me or the board does not like me, does not matter to me. I'm a straight shooter, and I'm gonna call it like I see it. So if you're gonna come in front of me with something, you better have it together. And honestly, the first time you didn't. You didn't have it together. We're beating a dead horse here. What we're telling our community is, hey, don't stop here and watch the Rockets. Spend your money somewhere else. What are we after? $6 of tax money after this guy? Are you kidding me? $134? Man paid $134 and then ride down the street again and then see if he don't try to come after the city. You got to be kidding me. We've got bigger problems in this city than this right here.
Excuse me, this is not the
That's
place
right.
for that.
That's
We're
right.
here for one thing, one thing
Okay.
only.
I'm not saying that there wasn't a violation of the ordinance as someone interprets. But the evidence and the exhibit that was presented to us, in my opinion, did not say that.
The minutes specifically say that the Florida Today article dated June 10th, 2019, and ordinance 46-2007 were submitted as composite exhibit number 5.
Okay.
Madam Chair, can I just make a couple comments?
Go ahead.
I think what, and we'll have counsel for the respondent speak as well. I just want to clarify what I believe the city is asking based on the motion and based on law. The city or any party can ask a board to reconsider its decision. That's within the purview of this board, and that is within the purview of either party to ask the board to take another look at something because either there was some kind of new evidence presented or there was a misunderstanding of the law. That's just basic legal theory. You can ask a judge to rehear something and reconsider something because you believe the judge may have misunderstood the law. And the way I'm reading the motion, this is what the city is requesting, is for this board to consider whether it may have misunderstood the law because the city attorney didn't emphasize it enough, or for whatever reason, I think that the ordinance is in the record, but I think due to the fact that it was unexpected, that the issue of whether the violation can only apply to the whole dwelling, I think that was totally unexpected. It was unexpected to me. I didn't think that the board would interpret it in that manner either. So I think it's appropriate for the city to request the board to reconsider, but we also have to hear the other side to determine whether they have any argument as to why you shouldn't reconsider your decision.
May I proceed, Madam?
Go ahead. Well, you have a question? Oh.
How many other multifamily units are in that neighborhood?
Do you mean single?
There's
No, I said
100,
multi,
there's
because
100 multifamily. Oh, multifamily?
Right.
No, there isn't any multifamily residents in that neighborhood.
So is it like a multifamily residence when you have other, when your family's living there and you have other families living there?
Well, the city put on evidence that it's a residential neighborhood. It's just a single-family residential neighborhood.
I don't think the facts are being discussed at this point.
What's the relevance of that?
Because
May I ask?
to me, it sounds like a I know that Titusville has very strict rules about where you can have multifamily dwellings. And when you have more than one family living in a house and dwelling there, it becomes multifamily. That's my point.
Well, if you want to consider a rehearing, I don't have a problem with that, because I said the reason why I made my decision last time because of lack of evidence. Now, if you want to present new evidence or something that is more inclusive, or all inclusive, okay? But but like I said, the summation that I was given or was shown last month did not spell out that this defendant was actually in violation. Yes, he was renting, yes, but the law as stated in 28.9 that you showed us, that we were given, that I was given, did not say that, okay? It said entire dwelling. It did. Detached dwelling. It said nothing about a room. That's where I made my decision. Now, if you want, I mean, someone said last time that we were being nitpicked. Well, the law is nitpicking. That's how, that's how the law becomes fair. When all the i's are dotted and all the t's are crossed. And last time, all the t's weren't crossed and all the i's weren't dotted, in my opinion. I can't speak for Ms. Evans or Mr. Edwards, but that's how I saw it.
I would not vote in a positive way for rehearing. I wasn't unclear about the statutes to be used or the legislative intent. I've been through this a million times. The only time they ever even tried to discuss portions of a structure was when they were talking about tourist taxation or transient taxation. And so there is no question of law there on my behalf. And I believe that a reasonable, prudent person could find the difference between an abandoned house and somewhere where somebody owns it and lives in it. I think that we all would act differently in front of a homeowner than being left by ourselves to do what we will with the property and the neighborhood and everything else. So I think there's a significant distinguishing that has to be done there between all or whole. And I don't have any legislative question based on the intent, the ordinance, or the city code.
Madam Chairperson, may I speak, please?
Go ahead.
The listening to the city attorney's original response, this law was written before Airbnb was invented.
Correct.
So that I think if we even allow that argument to come into it, we're talking about a city council at the time who crafted an ordinance who didn't know about this third-party application, which I think is important for your consideration for rehearing. Second, in listening, and I could be wrong, I think the city is surmising they gave you all this evidence, and maybe you didn't see it, which I think is, that's your prerogative to decide if you didn't see it or not see it. But there is, for looking for a reason of why we would need a rehearing. One is that the interpretation of law was erroneous, so that's saying that you as a board made the wrong decision based upon the facts, or that you as the board didn't have all the material evidence. And from our point of view, there is no new evidence presented, and the argument that they weren't prepared for an interpretation by essentially a pro se person, Mr. Daniel, who's not a lawyer, to argue about a word and interpretation of an ordinance, that's not sufficient. The city decided to file a complaint. The city has to anticipate all reasonable defenses. The city didn't do that, and the city has the opportunity in the proper remedy to either appeal your decision or which we think is more realistic, wait for another Airbnb case. They've had their chance. Now it's time that either for the city or the state legislature or for Brevard County commissioners to change the law, or it's time for them to choose a different case. But the Daniel family, outside of having to retain me, they've done enough here. And for them to have another hearing on the same exact facts would undermine the fairness doctrine of due process. And I've heard no new evidence that would support that they have something different to present to you, Madam Chairman.
Well, let me ask you a question, because you just brought it up. Are there any state regulations on Airbnbs at this point in the state of Florida?
Our prerogative is that there is no law that the Daniel family is violating that is state, county, or city. So to answer your question,
No.
there is no law. And so cities, and there's 67 counties, over 200 municipalities in our great state, we have the right as people to make choices, whether they're right or wrong. And you talked before, Member Edwards, about tourism. I mean, I'm born and raised fifth generation Orlandian. I've grown up seeing Orlando change in many different ways as part of our region, which is Brevard County, which is Titusville. We're all part of the super region. 72 million people came here last year. So when cities start talking about disrupting the great economic engine that drives up our property values, service, all those things, we have to be very careful. And I would argue that this board is here to enforce the code as it stands, not to make new law, and you made the right decision. It's on the city council, the county, or the state to make new law, and for us to go back and interpret a law that was written before this third party was even designed, Airbnb, would be inappropriate. And
So by stating that way you just stated it, then he's still in violation, the way you stated it?
No, ma'am. I'll correct myself if I did say that. My point is that the ordinance says dwelling, and I use an example. I looked at your, I'm not a city attorney, but I was looking at the fine ordinances of the county, and or the city, Titusville. One is 28-19, dog-friendly dining, which to my recollection is, it's almost 1,000 words. And I bring up this to you, just bear with me for 1 second. This ordinance about allowing dog-friendly dining actually goes into defining what is an outdoor area. What is an actual dog? Things that are important. If we have an ordinance that says dwelling or a room or a curtilage or things like that, clearly the city, when they pass ordinances, goes through the proper channels to spend the time, especially if you were to say on dog-friendly dining, over 1,000 words. Subsection 28.9 of the Titusville ordinance is silent on that issue. And because it says dwelling and doesn't say room or anything specific like I would argue 2819 does, that's a legal argument to show that what the city's citing is this cardinal rule. When there's ambiguity, go to the intent of the actual ordinance or the law. In my opinion, there is no ambiguity. If the city intends, and the city's been on notice since Airbnb and these places have been founded, if they want to change it, they would have done that. And
Their hands are tied, because we're grandfathered in under the 2011 legislation. So if we change or edit anything here, we now do not have the same 2007 legislation. But, I mean, it's not like there isn't an argument to be made about refreshing things and coming into modern days and dealing with the things that are in front of us. But that is why that's not a consideration right here, that they just edit so we can be more specific, because it's not a possibility.
Member Edens, I agree with you, but my point about 2819 about the dog-friendly dining is to show if the city council goes through this great length to define areas like outdoor and divisions and things like that, and is silent on our section in regarding to a dwelling and the rental of that, that should go to show you that there is no ambiguity. There isn't. And so going back saying, I wasn't prepared, let's go back to this legal doctrine, we weren't prepared, that's not an appropriate remedy. The appropriate remedy is either they appeal it or they bring a new case. But to make the Daniel family have to come back and do another hearing would be inappropriate. I can answer any questions if there's any questions.
Madam Chair?
What? Go ahead. Yeah, go respond. We'll let Chelsea, go ahead and respond, Chelsea.
A couple things. Florida was one of the first states to enact a law on dogs in restaurants in 2006. The law allows a unit of local government, like the city of Titusville, to adopt an ordinance that acts as an exemption to the state's FDA food code. Once the local exemption is passed, a restaurant can apply for a permit to allow dogs in the outdoor dining spaces. Certain things must be included in the ordinance, such as a requirement that staff wash after touching pets, a rule that patrons keep dogs on leashes and under control, a prohibition against dogs on chairs, tables, or other furnishings, signs that list the rules for employees and patrons, and a cleanup station in the outdoor dining areas. There are also reporting requirements by the local governments to the state of Florida under the law. The city or county must also have a system in place to document and respond to complaints. That's a summary of the 2006 state law that says if you, city, want to go ahead with dog-friendly dining, you must include all of these specific criteria in your code. And that's what the attorney was referencing. We didn't create the dog-friendly dining criteria. We copied the state legislature on that issue.
So back to the state legislators, have they made rules and regs on Airbnbs for the state of Florida?
They have one sentence that says local governments that have enacted legislation prior to June 2011 are grandfathered from following everything that proceeds on. I don't have that statute in front of me, and I'm sorry.
But their ruling basically says that local city agencies should not be regulating vacation rentals.
It says you can't create new law. It doesn't say you should not regulate. It says if you have them, good, you're allowed to keep your laws on the books.
Okay.
So I have one other tool that I'd like to show you. I didn't know if this would be helpful, but member Beckles brought up the zoning category, so I figured I'd show you this. If I could get the PowerPoint of the zoning map on the big screen.
I just want to ask, if this is not a new evidentiary hearing,
I just want to show a map of the city to show zoning categories, and I don't have to display this if you object.
right, I would object because I
Okay.
would object to any new evidence at this time.
That's fine. Please disregard the PowerPoint request. I wanted to show the zoning categories where this code applies and does not, but I will not do so today. I wanted to lastly.
Do we have the option to see it? Because like I said, this is not.
No, not at this time, sorry.
It's not a court of law, and so it's not like, we're not under the same rules as a court of law, so I don't, just because he objects, I don't think that doesn't mean you can't show it.
I beg
If
to
I would
differ.
like, if someone would like to see it like me.
Chelsea, would you agree that the zoning is just, you're just asking for judicial notice, technically like judicial notice of existing zoning categories?
Yes. I can get to that, but I would like to add one further comment in response to the respondent, in that he's argued that this board is not able to hear this reconsideration because the issue has been decided res judicata. However, you all, 6 of you were here present at the hearing, and there was significant debate over whether or not the decision should go one way or another. And when there is a vague law in front of you, then yes, you must be open to reconsideration and further information to determine your interpretation on the law that was presented. And I argue that this short-term rental code is vague because it does not define a part thereof in the word dwelling, which is what the city council intended to mean. I again ask for a motion for reconsideration on this matter.
I'd like to make that motion.
May I have a question? Why do we have a display of the zoning map?
I thought it may be a helpful tool
even
to show
though
you.
Even though the gentleman objected?
Well, it popped up before.
I would like to help this board make their decision, and I would like to provide this board with any tool that may help you. So if the board asks for it, I'll bring it back.
Oh, it's up.
It's already up, so let's just take it off. Let's just take it off the screens.
It's on our laptop.
It's up on the screens here, our screens.
Yeah, my question was if he objected to it and no one ruled yay or nay, why is it up here? Why are we seeing it?
Because it came up before, while he was putting it up, while they were talking about it.
Okay.
Well,
Technology.
I mean, what I'm looking at right now, I can't see anything on it, so it's, to me, I can't see any kind of value to what it is. It would have to be explained, so if there's a need for the board to get an explanation of the zoning map, then we
My
can.
understanding was this is not legalese, this is due process rights for my client, the Daniel family. It's a closed universe on the facts. This is all legal argument. Even if they're trying to introduce something through judicial notice or some other remedy, this is a closed universe. This is, did you not have new evidence, which there's been no new evidence to suggest that you didn't have all the evidence, or was there some legal argument you didn't understand? So our position is that if there is a motion for a vote, which obviously that's your prerogative, we would just ask that there be a clear vote so we can understand what we're doing here, Madam
Clear
Chair.
vote would be a motion of whether that we would consider it.
All right.
Yeah.
Then we would just ask as well, Judge, and then Member Munoz, who was asked to recuse himself last time, would recuse himself this time as well, Judge.
That's already been determined.
All right, thank you.
Mr.
Madam Chairman?
Did you have something you wanted to say? Mr. Broom? No? Okay. Yes.
Okay. I've been a member here for over 10 years. And what the city's asking is just to take a look at this case over again. We've had people that we've found them in violation and that have come back at another time and asked for forgiveness or, to relook at it. And we have set a precedent and we have done that. Now, I'm the 3rd oldest member on this board. The rest of yous come in here 2 years, maybe? 2 years?
5 years
And
or
you,
less.
and Ashley, you'd be probably, Ashley and RJ would probably be the oldest behind me, right? I see no problem with taking a look at this over again for the city because there was miscarriage of justice that was done. There was a self-admission 38 times of violating the law. You rented it. It was in a newspaper. Everybody read it. This is not a secret. Everybody read this. He admitted the fact that, well, except you maybe.
Okay.
Right,
Go on.
right, we're not
But I'm not gonna go over any
rehashing
further
the
than this.
facts.
Also, for the attorney's benefit, I live in the neighborhood. directly across the street from the Daniels.
Mr. Moonis,
Okay,
let's
that's
not
not-
get any more
We're just here
evidence.
to-
This is not an evidentiary hearing at this
Okay.
point, so we can't talk about any evidence.
Okay.
I would just like for the record that to be known that he lives across the street, and he's saying it's a miscarriage of justice.
Well, I understood, I heard that, so just, sit down, please. So what we're here is to decide if we want to do a motion for reconsideration to reopen the decision based on 6/10/19.
Only if all the exhibits that was presented last time is in evidence next time.
Put that in your motion. Who's going to make a motion?
Mr. Herman said he was going to.
All right, go ahead, Mr. Herman. Yes, go ahead.
I simply move that this board reconsider the issue based on the evidence that we've heard here today, which is above and beyond what we heard last month.
Again, for the record, there is no new evidence that's been presented today. I want to make that clear. That's from the city's position.
Correct.
So that motion from our position would be, that couldn't carry because there's been no new evidence.
Mr. Herman, can you amend your motion, please? Or restate your motion?
What, excuse me?
Restate your motion again.
I move that this board reconsider this issue.
Okay.
How can he do that when he wasn't here last month?
He can make a motion to reconsider it.
He can move to reconsider. He can vote on the reconsideration. The facts aren't in dispute.
Huh?
The facts are not
The
in
fa-
dispute.
the
It's
facts
not
are
the
not in
facts,
dispute.
It's reconsideration. Do I have a second?
Second.
All right, I have a motion by Mr. Herman, a second by Gina. Any discussion?
Will the evidence or exhibits from the last hearing be presented to the new, if there's a new hearing?
If this board agrees with the motion for reconsideration, my next question is if you are vacating and setting a date, vacating the prior decision and setting a date for rehearing. And the city is willing to do that at either next week, if you do not vacate the decision, or at your next board meeting in August, a regularly scheduled meeting. If the decision is vacated, then the city would ask that the rehearing occur at your regular August board meeting to allow both parties time to present their evidence.
If we do not vote yes on this motion, where do you appeal?
To the circuit court,
So the decision comes out of our hands.
after this decision, yes.
Can I respond to that, please? I mean, she had a chance, I'd like to respond. The decision of this particular case does, but, that doesn't mean that sets a precedent per se. Every case is different upon the facts. And I think that that's very important to consider, and I want to be clear, from our position as the defense on the Daniel family, there is no new evidence. They're asking you to reconsider the law as is. Nothing new would be submitted from their point of view at a new hearing.
And I think you're just hammering home my point in that if any of us feel like we did the right thing last time, then we cannot hear this issue again, and they can appeal to the proper channels, and someone else can deal with this
Yeah.
legislatively,
Let's let that happen.
just to make sure that we all understand that.
Yeah.
And as I stated, if the exhibit that was presented to the last one is not presented to the next one, then
Chelsea, whatever the motion is, or based on the motion, will all the exhibits you had last time be presented at the next time, if it's so
Absolutely.
determined? Does that answer your question?
sure.
Okay. All right, we have a motion, we have a second, we have some discussion. Anything else? Roll call vote, please.
Member Edens?
No.
Vice Chairman Beckles?
Yes.
Member Grant?
No.
Member Herman?
Yes.
Member Edwards?
No.
Chairman Bell?
Yes. All right, we got a draw. So there'll be no rehearing.
That concludes the agenda.
That concludes the agenda.
My last request is that any member of the board may make a motion to rescind the prior decision. Is that right? Or does Mr. Moniz continue have to recuse himself?
What would be the basis for a motion for rescission?
It would be up to the board to make, that would be an opportunity for them under Robert's rules, and so they are aware of any motion that they could make.
That's a conflict of interest, ain't it?
Or
Well,
any other
I
member.
think under Robert's rules that the board does have the ability to rescind a previous order.
I don't understand, what exactly does that mean?
Maybe
It's
counsel
the
for
city's
city
last-ditch attempt at getting a decision in its favor on this motion today.
So you're saying that the gag order, for lack of a better term, on Mr. Mooney's would be lifted, is that what
No,
you're saying?
she's saying that any board member here has the option to rescind a previous decision. So if I made a motion to recede my previous decision,
Right.
then we would, I don't know, it would all start over or something. But one person can make that one motion, is what she's saying, and it's their Hail Mary.
And you're not on your microphone.
Sorry.
I heard you.
Okay.
Anybody want to make another motion? Ask her. I don't know.
I would like to ask the board members, now that we have agreed to reconsider this matter,
We have not, it didn't
No,
pass.
didn't pass. It was a
The-
3-3 vote.
The motion did not pass.
It did not pass.
I would like to suggest a revote on this issue based on what we've heard so far today.
We
You mean-
just did.
Oh, no, wait a minute. You're asking for a revote on what?
The issue,
Well, we can't do that.
the entire issue of whether or not there is a violation of the ordinance.
Can't do that, can we?
Well, if he's moving for the board to reconsider at the last vote, is that
The
what
vote that we
you're?
just did today, or the vote from 2000, or from June 10th?
But that's what the city has already asked.
The vote from June 10th.
Nope, that can't be done. So we just did that.
That's what we just voted on, to reconsider the previous vote.
Yes.
That's what your motion was before. And we voted on that, and it was a 3-3, and it goes to the noes.
I think we heard some information today that, that did provide the reconsideration. What I'm saying is that we recognize that, and I propose that this matter may be ready to go away with a revote on whether or not there is a violation.
No. 3 of us said yes,
Okay.
3 of us said no.
Okay.
Chairman, I asked that would the agenda be concluded, we'd be allowed to recess and leave now. There would be nothing further.
Go right ahead.
Does the
We
city
have a few
attorney
more
have
things on our
any,
agenda.
any basis for a reconsideration of the motion for reconsideration?
No.
Reconsideration of the vote on the motion for reconsideration.
No, but I would like to
Under
clarify,
Roberts.
when I stood at the podium, I was talking about a motion to rescind the prior order, not the decision, a motion to rescind the order of case number 19-28, which this is the subsequent meeting, and so that's this, as I said, the city's last-ditch attempt to get a decision in the city's favor on the city's motion for reconsideration, or in the alternative, rehearing, which is the title of my motion. And I say that to allow for the opportunity to rescind and vacate the prior decision. A motion for reconsideration is different from a motion to rescind.
Can we take a few minutes and adjourn?
No, it's a public hearing, so we can't, we have to do everything in the sunshine here. If there's a board member who's interested in a motion to rescind, you can put it out there on the table, and then there could be further argument as to why there should be a rescission of your previous order.
We've talked about the motion of possibly looking at everything again several times, and each time there's been silence. So if there's nothing further, we would like to conclude this matter, but I certainly am hesitant to leave when I feel like there's going to be things happening outside my presence, so. Very well. Thanks, guys.
All right. Chelsea, you have anything for board attorneys, or no, Deborah, you have anything for board attorneys report?
Nothing.
Chelsea, you have anything for city attorney's report?
No, ma'am.
Me neither. Any board members' reports? Meeting adjourned.